Select committee.
No, my lord, law commission's report, which courts select committee.
He has not filed. इसमें मिलेगा. Is Justice Gajendra Katkar's report, no?
Yes, yes, my lord. No, it's not there, my lord. I'll, my lord, place it within 10 minutes.
All right.
Allow me to
Just
read.
read it.
In the documents folder.
Volume 10.
Mr. Solicitor, just read it out. It will be a short, one paragraph.
There is one paragraph, my lord.
Just read it, that's all.
Why 21A was brought in. It may not be necessary to shuffle through, my lord. I'll just read, my lord. In our opinion, that the select committee says, in our opinion, it is desirable to exclude from the scope of this section cases where both the parties are Hindus. In such cases, the law of succession, otherwise applicable, should continue to apply. We see no reason why the fact that the parties choose to marry under the Special Marriage Act should make a difference in such cases, i.e., where both are Hindus. We recommend that such cases should be excluded from Section 21.
Oh, I see.
Yes. But the reason was, registration of a marriage has never been compulsory. Even today, it is not compulsory. It's a personal choice, whether it is under the Special Marriage Act or under the Hindu Marriage Act or under any other marriage act.
Registration. But it does not make it valid if you don't register. Correct me, I think it is compulsory, but failure to register does not render the marriage void or an irregularity.
Compulsory.
Maybe, it depends. But
Hindu Marriage Act, it's not compulsory.
Compulsory, is it? No?
It's not.
And what is
but my lord,
Special Marriage Act?
the deterrence was,
Yeah, that is meant for registration.
Lord, there were many marriages in those days when this 21A came, which were solemnized.
You can inquire from across the people in the court, how many have marriages.
My learned senior says his marriage is not registered.
Same here. Same here.
Where is the proof, Mr. Dwivedi? Where is the proof?
He'll raise our hands.
Well, we
If I'm not wrong, I think this compulsory requirement of registration of marriage was introduced a few years back when they said,
Recently.
even if you are married according to Hindu law or any other thing, you must
yes.
register your
My
marriage.
lord, earlier what used to happen, the marriage would be, my lord, solemnized as per Hindu rites, Saptapadi, etc., not under Special Marriage Act. But I want a certificate of marriage. So, therefore, my lord, it became a deterrent. That if I take certificate, I'll not be governed by Hindu Succession Act.
Right.
I think one state used to, it used to be
State
compulsory.
provision, there is no
You
national.
know,
There is in
because of
Tamil Nadu.
8.2, because of section 8.2.
Yeah.
8.1 says the rules may be made, but 8.2 says that the state may make it compulsory.
Yes.
But it
Tamil
also
Nadu.
says that if you breach it, it will be only punishable with 25 rupees.
Yeah,
It does not affect the validity of the marriage.
Correct.
80% of marriages in the villages, they're not registered at all.
Absolutely, you're right.
Tamil Nadu, I think, made it compulsory.
It is socially.
If I'm not
accepted.
wrong,
Now,
Mr. Datar, I think
relatives collect. and then
Absolutely.
it's known that-
Ordinarily.
Tamil
Mr.
Nadu, it became compulsory
But
because of that form, no, self-respect marriages. Swayamvadayam. So that was made, I think,
Right,
section
yeah.
7A or something was enacted.
Otherwise, you have to take evidence of, show your wedding photograph, album.
And if you require a visa,
Certificate
you
from the
require a marriage certificate.
Only for visa, it will
Visa, another thing.
marriages could be solved.
My lord, therefore, section 15 came. Section 15, my lord, is registration of marriage is solemnized under other laws. You can still get a registration, which may not be governed by
15 of the
registration.
Hindu Marriage Act.
No, my lord, Special Marriage Act, section 15.
That is, of course, there.
Your Lordship has section 15.
Yes.
Yes.
Any marriage celebrated, whether before or after the commencement of this act, other than a marriage solemnized under the Special Marriage Act or under this act, may be registered under this chapter by a marriage officer in the territories to which this act extends, if the following conditions as set is fulfilled: the husband and wife, etc., etc. So, my lord, if there is a marriage as per Hindu rights, not under Special Marriage Act, I can go and get it registered, my lord, under section 15.
In other words, if notice, the notice mode is accepted, then the registration itself is a marriage ceremony.
Yes.
This
It's
is-
a marriage certificate. But it
Itself is a marriage
Yeah.
ceremony.
Just go to the and get yourself registered. Yeah. And interestingly, see how well that section is worded. Section 15 says any marriage celebrated.
That's right.
So celebrated
Not
would mean
solemnized.
anything, not solemnized, celebrated. You have celebrated the marriage. You have invited 20 friends,
recently,
you
my
have
lord,
celebrated it.
Datar told me that a week before, the marriage was 2-minute affair, I think. He attended a marriage, my lord, in Chennai.
It's
Called self-respect marriages.
That's all.
That's all. No other.
And then you can get it registered here.
I think if the Lordship says Hindu has some 8A or something section where they have.
7A, I think it used to be there.
Amendment.
The Tamil Nadu amendment, no? Yeah.
I think it's the second shortest, I mean, this,
Yes, 7A, Tamil Nadu.
After section
Swayamvar.
7A.
Yes, well, that's a Tamil Nadu amendment, my lord.
That's
Yeah,
in
Swayam
60s, I
Mari
think the
Thai,
first,
Swayam Mari Yathai marriage.
I
That is
think it was
Swayam.
made in the 60s, right?
68.
68.
yes.
The first government of,
After the DMK government.
yes. after the-
1967, with effect from 20th January 68.
Even came, my lord.
Tamil Nadu.
Yes.
Yes. Lord, please see section 18. Why this was a deterrent and 21A had to be brought in. My marriage is solemnized as per Hindu rights or as per Muslim nikah right, whichever way.
Interestingly, 15 also uses the expression husband and wife.
Husband and wife. Well, there's more than once, my lord, they are husband. For example, my lord, your lordships may see 12. 12 proviso, last, my lord, last line, lawful wife or husband. Well, but there's several, my lord. I'm not reading everything because there are several places. My lord, but 18
Their
says,
contention, of course, was wherever it's husband and wife, treat it as spouses or person.
yes, my lord, that
But your contention is that that's not enough. You will have to, because there are so many other interlanguages which you can't
then you will have to restructure or redesign.
It's
or
not according to you just a question of reading the expression person for husband and wife or just spouses or for husband and wife.
Yes, my lord. Now, my lord, please come to the divorce. And there is some, my lord, substantial ground on that. Divorce, my lord, section 27. Subject to the provisions of this act, I'll not read everything, my lord, because the contents are not relevant. The purpose is different, my lord. The subject to the provisions of this act and to the rules made thereunder, a petition for divorce may be presented to the district court either by the husband or the wife on the ground that, Lord, these grounds are available to both husband and wife. Correct, my lords? Now come to 1A. I'm not reading the grounds, my lord, not relevant for the purpose. 1A. A wife may also present a petition for divorce to the district court on the ground that her husband has, since solemnization of the marriage, been guilty of rape, sodomy, or bestiality, that in a suit under section 80 of so and so, 125 of CRPC, so and so, a decree or order, as the case may be, has been passed against the husband, awarding maintenance to the wife, notwithstanding that she was living apart, and that since passing of such decree or order, cohabitation between the parties has not been resumed. Now, my lord, the answer to this was by the other side that let both have both the grounds for divorce. Lord, as I recollect correctly, Lord, when this was pointed out, that there are separate grounds available to both, and 1A applies only to wife. So who will be the wife? In a man-man marriage, in a woman-woman marriage, or in a man transgender or woman transgender marriage, or two transgender marrying, who will be the wife? The answer was that they would both have both the grounds. Now, Lord, there is a problem. And the problem is, can your lordships read a statute which gives one additional ground of divorce to one class to the detriment of heterosexuals for which the Special Marriage Act is enacted? So there would be a class within the class. If I am heterosexual, I will not get as a man the grounds under 1A. Otherwise, wife also can be guilty of rape, bestiality, etc. But if it is a same-sex couple, 27 would apply differently and both would be available, my lord. That would be not, my lord, a correct way of interpreting statute, my lord. Applying one section in one way to one class and differently to the class for which the act is enacted.
Yes, Mr. Solicitor.
Lord, please come to page 31, section 31. Court to which petition should be made. This is again not reconcilable. Section 31. Your lordship gets, my lord?
Yes.
Section 31, my lords. My lord Justice Narasimha gets, my lord.
Yes, yes.
Every petition under chapter 5 or chapter 6 shall be presented to the district court within the local limits of whose original jurisdiction marriage was solemnized. Respondent at the time of presentation resides. Parties to the marriage last resided together, or please see 3A. In case the wife is the petitioner, where she is residing on the date of presentation of the petitioner. In case of a gay marriage, who will be the wife? In case of a lesbian's marriage, who will be the wife? In case of a transgender marriage, who will be the wife? These questions will arise. And my lord, we cannot leave it just that in individual cases, they would be taken care of. Across the country, this would arise. Lord, now kindly come to section 36. Alimony pendant light. The lordship gets, my lord? The lordship gets, my lord? 36. Yes. Where in any proceedings under chapter 5 or chapter 6, that is judicial separation or divorce, it appears to the district court that the wife has no independent income sufficient for her support, and the necessary expenses of the proceedings, it may, on the application of the wife, order the husband to pay to her the expenses of proceeding and weekly or monthly during the proceedings such sum as having regard to husband's income, it may seem to the court to be reasonable. Now, my lord, if your lordships were to read person, applicable to all, then, my lord, right of a non-LGBTQ wife will be taken away, because then husband can also claim alimony from her.
Just come again.
My lord,
But that's
Yeah.
happening in heterosexual marriages too, Mr. Mehta. That's I mean, we've all come across it at different times in our jurisdictions where the husband also claims.
but here only wife is given right. Please read it again. From the husband. My lord, may I, Lord, slightly rephrase this? My lord. It says, if the wife establishes that she has no means of income,
Right.
she can apply, and husband is under an obligation to give her maintenance pendent lite. Now, my lord, first of all, there cannot be any decision by the court who is the wife in same-sex relationship. I'm not elaborating, my lord. But if your lordships were to read person instead of husband and wife, correct? So one person will be entitled to claim maintenance from another person, meaning thereby, in case of heterosexual marriages, to which this act applies. In fact, it applies only to them, according to us. A husband can also claim maintenance pendent lite from wife.
And
Heterosexual.
alternately, if it is interpreted to read as person only in the case of a same-sex marriage, then there will be a distinction between same-sex and heterosexual couples.
That again.
Because in the case of a heterosexual couple, the husband cannot claim maintenance under 36. But in the case of a same-sex couple, we would be reading it in such a way that either spouse can claim it from both.
But one of the men can. If he claims that I am the wife,
Oh, it depends. Yeah.
he says I am the wife. Or in a lesbian couple, one of them says that I am the wife.
Depending
Because
on
one of the arguments
orientation.
made was if you identify yourself with that
There's a
role.
orientation.
Orientation, role was the word used.
Role was
That
the
I
word
play the role
Right.
of a wife. And which court, my lord? How can the court decide what is true?
That will
Suppose
become a preliminary issue.
it would be.
That will become a
Jurisdictional issue.
It would be. My lord, therefore,
preliminary issue.
and
It's maintained.
That's an impossible.
and again, my lord, fundamentally,
That inquiry, to say that who.
apropos your ladyship's my lord, remark, your ladyship is right. Under section 24 of the Hindu Marriage Act, that permits both husband and wife to claim.
Either party to marry.
Yes, my lord.
That's why we've come across in many.
Yeah, we lordships come across, because 36 of this act restricts only entitlement to wife.
Wife.
It was a in that sense, it was a progressive enactment.
Yes.
It went beyond because it recognized that
It could be a husband.
Any one of the two
could be one
spouses
of
could
the
be
two.
destitute.
Even
But they would-
section 124 CRPC
I was just going to say-
entitles even parents to claim
Yeah.
maintenance. Parents, children, etc.
of those things came because of amendment.
In Muslim law, my lord, it's different again.
For 125, the obligation is straight on his wife, neglects to maintain his wife.
Your
His
lordships are on
legitimate or
125?
illegitimate, 125.
125, my lord, yes.
His legitimate or illegitimate minor child.
His wife, unable
His
to
legitimate or
obtain
illegitimate
or
child. His father or
legitimate
mother.
illegitimate children, his legitimate or illegitimate child, his father, mother, etc.
125 doesn't apply to women.
That's again is
Then a
restricted
husband
to.
or
But 24% talks of husband or wife.
Yes.
Any of the two.
Either way, my lord, if wife is more, my lord, has more means of, my lord, income, etc.,
Strong.
then husband can also, my lord,
That's right.
claim maintenance. Now, my lord, last section, 39A, Special Marriage Act. I am not, my lord, troubling your lordships any further. 39A, enforcement of decrees and orders. All decrees and orders made by the court in proceedings under Chapter 5 or Chapter 6 shall be enforced in the like manner as the decrees and order of the court made in exercise of its original civil jurisdiction for the time being are enforced. Well, Lord, I'll show there are separate provisions in CPC for execution for male and for female. Sixty-one. Lord, now,
Mr. Solicitor, therefore, looking at the conspectus of these provisions, perhaps we can conceptualize your argument by saying that reading the provisions of the Special Marriage Act, and if the court were to make an effort, as the petitioners say, to reinterpret the provisions, there would be three major problems. One, it will involve substantial rewriting of the legislation. Two, it may also involve the court ignoring some provisions which have been introduced as a matter of public policy, as we saw the additional grounds in the case of a woman for divorce. And third, it would involve reinterpretation of personal law, because there are segments of the Special Marriage Act which specifically contain a reference to the personal law. So there is no way in that, the third category, there is no manner in which the court can avoid the interface between the Special Marriage Act and personal law.
And I'll respectfully add the fourth, that court would not read any statute so as to make it applicable to one class differently and another class differently.
Court cannot adopt a dual approach.
Let's check. I didn't follow that.
The philosophy permits.
Yes.
Yeah,
And my lord, there are several questions, my lord. Some of the questions were
Mehta, just to clarify, 39
Everything
once
is one.
more.
Everything is not one. Our philosophy.
Lord, and with the ingenuity of lawyers and litigants, my lord, it may not be a far-fetched idea, my lord, that a heterosexual couple can come and say that now apply me the provisions which you have read for LGBTQ, because we may be heterosexual, but internally we are not. I feel different way, etc. I don't wish to elaborate any further, but it opens room for several my lord, complications which your lordships cannot conceive right now. So now,
will you repeat yourself on what you were pointing out in section 39, appeals from decrees and all? What was the point you were making?
Core of our philosophy.
Section 39.
39A, my lord, the decree will be executed as if it is decree of the civil court under civil procedure.
Right.
And I'll show there are separate provisions for male and female under the CPs.
We can't read.
And mail it to Mr. Mail it to the solicitor. Yeah.
Solicitor.
Yes, my lord. Now I'll just quickly, within 10 minutes, 15 minutes, show your lordships, my lord, how other provisions would become unworkable. Quickly, just illustratively. Please come to my first note yesterday file, my lord, page 61.
Just 1 second.
My lord, it is note 1. It's a submission on the question that only legislature can deal with. That's, my lord, the title. Yesterday's note, my lord.
Yesterday's note.
Note
Page
one.
61, that is 64, PDF 64.
Just 1
65.
second.
Sorry.
PDF 64, note 1.
God, not 1. PDF 65.
You can't get
Yeah, yes.
petitioners.
Lord, now
Para 112,
114.
114.
Next page, brother. Maybe you're ready.
Yes. No, you had read up to 113.
Yeah, yes, sir. But 114. I'm not going to read the whole.
What's
I'm
the
just giving
PDF
the
page?
flavor of other provisions, which will be affected, my lord, which are not before your lordships. Now, my lord, Indian Succession Act undisputably applies.
65.
Yes.
My lord, Indian Succession Act undisputably applies to all except Hindus. Hindu would be governed by the Hindu Succession Act. In a given situation, if he marries Hindu, otherwise Indian Succession Act. Now, this also, my lord, kindly just 1 or 2 sections, just for the flavor. Domicile acquired by woman on marriage. By marriage, a woman acquires the domicile of her husband if she had not the same domicile before. So it will have to be decided who is the woman. Wife's domicile during marriage. A wife's domicile during her marriage follows the domicile of her husband. For passports, etc., this issue would arise and you will have to decide who is the wife. I'm not reading all, but my lord, Succession Act provides for widow, widower, husband, wife, father, mother, etc. Well, just highlighted part also, if you can, lordships can read. 33A. A widow but no lineal descendant and the net value of his property does not exceed the whole of his property shall belong to the widow. Now, my lord, if in this relationship one partner dies, whether he leaves behind a widow or a widower, then, my lord, your lordships may see 43 at the foot. In the intestate's father is dead, but the intestate's mother is living. Now, my lord, next generation. My lord, marriage is permitted, they adopt, and someone dies. And father and mother is, my lord, LGBTQ couple. Who will be treated as dead as father and who will be treated as dead as mother? This would be the, my lord, dilemma and can't be, my lord, foreseen by your lordships. Now, please come to 115 and quickly, my lord, I'll take your lordships through the flavor of, my lord, other 160 sections which will be affected. Though they are not arising here, my lord, for your lordship's consideration, but inevitably they would be affected. They are not in question, they are not for interpretation also. But the moment your lordships reads the word person, in case of man and woman, wife and husband, these are the consequences which will follow. Just, my lord, highlighted part, and I'll read only some sections. I'll skip remaining section. Please see 1. Section 3G, degrees of prohibited relationship. Your lordships have.
Where are you?
Sorry,
Where are you reading?
Lord, I'm sorry. Page 115 of my yesterday's.
Where
We were looking at.
Yes,
Even I was looking at that.
115.
No, I'm sorry, my lord. Page 115. My apologies.
Mr. Solicitor, what PDF page is it?
It was 119, lords.
119, right, Hindu Marriage Act
Yes.
on the top, right.
You are giving us PDF pages by asking your junior. You are supposed to give us PDF pages by having your own.
No, my lord, I
electronic pad
have
open.
calculated it is +4. So it's a simple formula, my lord.
Mr. Solicitor, I'm putting you on notice. For this matter, fair enough. Now we have exempted you, you know. But we are not going to read down the statute in the next matter. You have to have your iPad open. You're not going to be looking at Kanu and asking him to give you pages next matter.
I am already in.
Get ready and.
My lord, I am already.
Otherwise, we'll ask your junior to argue.